Hello everyone, this is the video of Legal Studies class 12 unit 2nd, that is topics of law, and the topic that we are going to discuss in this video is contract law. Discussing anything about contract law, I would like to just give a brief account about the contract, basically brief understanding of the contract. You know that our every act involves contract some way or other way. If we buy a pouch of shampoo, that is also part of contract. If we buy a costly car, that is also a contract. If we book online ticket, whether it is a flight or train or even movie ticket, that is also covered under contract. So our every act of such type involves contract. I believe you must not noticed it by the time, but from now onwards you can or you should start noticing it, because you know, if you come to know the meaning of contract, then of course you come to know your rights, because contract also puts certain liabilities, certain rights both. Okay, so being a consumer, if you are buying something, then the seller has certain liabilities and you have certain rights. If you get some defective products, then how you supposed to be suing the seller until you know the rights, isn't it? So you should know the rights, and if you have the right, even you know the right, being a consumer, you have the consumer right. But under which law that right is defined? So you should understand this again. So through the contract you can define your right. So this is the way you can appreciate your right, and you can claim whenever you are or you will be cheated through a product or through anything. So that is basically the overview of a contract, that we are into this, whether we want it or not. We are every day participating in some contract, directly or indirectly, isn't it? So now let's check it out. What are the key terms that we are going to discuss in this video? Of course, the first one is meaning and concept of contract. The second one is principles of contract. What are the principles? Let's check it out. Offer, acceptance, consideration, capacity to contract, free consent, unlawful object, discharge, remedies, impossibility. So these are the principles that we are going to discuss. Though, or basically essentially, we will not discuss all these terms in this video, rather we have number of videos on this topic, because in one video it is not possible to define all these terms. So in subsequent videos we will be discussing, but you should understand these are the principles of contract. Okay, so now let's begin with the meaning of contract. What is basically meaning of contract? So in a general, whatever the definition or meaning or understanding of contract has, that we understood through the example that we have discussed now. Now what law says and how law defines the contract, we will discuss that. Okay, so let's begin with that. As we have discussed that the contract is governed by the contract law, and that is executed in 1872, namely Indian Contract Act 1872. Now let's begin with the technical part, that is legal language of the contract. So we have discussed already the law that governs the contract, that is Indian Contract Act 1872. So we will be discussing everything about the contract in the framework of or in the language of Indian Contract Act 1872. So this section 2H of Indian Contract Act 1872 defines contract as an agreement enforceable by law is a contract. So it's very simple definition that an agreement which is enforceable. So where you need to focus, that is on enforceability. If it is not enforceable in the law, then it is void. But if it is enforceable, then it is contract. A contract which ceases to be enforceable by law becomes void. So until it is enforceable, it is valid contract. The moment the enforceability ceases, it becomes void. So now you understood that where you need to focus on, that is enforceability. Without that, you cannot imagine contract. Now, as we have discussed that an agreement enforceable by law. So now you must be thinking that what is an agreement? So now let's check it out. Every promise and every set of promises forming the consideration for each other is known as agreement. It is defined under Section 2E of Indian Contract Act. So what does it mean that if you are making a promise with consideration or set of promises, as said here, but don't get mesmerized by the language. It's legal language, always complicated. So focus on the simple sentence. That is, every promise or set of promises, if it involves consideration, and we know that what is consideration, that is money or some benefit. So every promise and every set of promises forming the consideration. So without consideration, it won't be imagined. For each other. So each other means both the parties need to be benefited. It's not one way, not at all. So both the parties need to be benefited, known as agreement. So promises or set of promises forming the consideration for each other. So that is an agreement. And enforceable agreement is contract. An agreement which is not enforceable by law is said to be void. So simple. An agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other or others, is a voidable contract. What does it mean? That if there are three parties making an agreement and then two of them believed it or made terms and conditions that it will be enforceable by the law, but it is not applicable for the third party because he is supposed to be neutral. But in terms and conditions or in basically contract, if all three are involved, then if one party is not active in the sense that his terms and conditions is not enforceable, then the contract is void. So everyone should be given the equal right. Okay. Now, what the definition we have studied, that is regarding the agreement, that is every promise or set of promises. Now you must be thinking that what is promise then? So now let's come on what is promise. When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. Section 2B of Indian Contract Act. So it is defined by Section 2B of Indian Contract Act that when a proposal is made to you, okay, just understand it with an example. If someone came to you and made proposal that he wants to sell his car to you, so he is keeping his proposal, okay, and once you accept it, that become promise, isn't it? So it is saying same thing. When the person to whom the proposal is made signify his assent, means he gives his assent, thereto the proposal is said to be accepted. So you accept the proposal, it becomes promise. Okay. Now promises which form the consideration or part of the consideration for each other are called reciprocal promises. So it is simple that if both the parties getting benefited out of that, making promise, accepting the things, then it is reciprocal. And you know the meaning of reciprocal is. So it's the same meaning. The next point is the person making the proposal is called the promiser, simple, and the person accepting the proposal is called the promisee. So two terms that you need to keep in your mind. Promiser, who is making the promise, and promisee, who is accepting the proposal. So now check out the definition of promise again. When the person to whom the proposal is made. So again you understood what is promise is, because if someone making the proposal and that proposal accepted, it becomes promise. Now the question is, what is proposal? As per section 2A of Indian Contract Act, when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. Well, I believe again you get lost in the language, but don't worry. The language, though difficult, but I make it simple by breaking it. What it's saying that when one person signifies to another person his willingness. So pay attention on the word willingness as I highlighted here. Willingness means if someone comes to you and says like this that he wants to sell his car. He is not saying directly something like, will you buy my car? Rather he is saying, I want to sell my car. Okay, and the one thing more it is said here, to abstain from doing anything, or abstain means just restraining you. You don't need to do that. It's not essentially to do something that is contract. If something asking you not to do that based on certain terms and conditions and everything, that is also included under this chapter. So to abstain from doing anything with a view of obtaining the assent. With a view of obtaining the assent means if someone came to you or saying that I want to sell my car, and his intention is that you are going to buy his car. So that is his intention, the person who approached you for this. So obtaining the assent of that other to such act of abstinence, he is said to make a proposal. So it is a proposal. So he came with his proposal and you accept. When you accept it, basically it becomes promise. So again, I believe you might be confused among all these terms because I have used so many terms starting from the top level: contract, agreement, promise and proposal, like this. So we have discussed it from top to bottom, that is from contract to proposal. Now let's check it out from bottom to top. So whatever the confusion you have, it will resolve that confusion. So that is proposal as defined in section 2A. You please remember this section. Proposal, that is initiating, someone came to you, shown his willingness to sell his car. Okay, so with the intention that you will say yes or accept it. So that is proposal. Once you accept it, that becomes promise, and the promise, that is section 2B. And then promise with consideration, that is mutually beneficial, become agreement. When promise involves consideration, it becomes agreement, and when agreement is enforceable in nature, that becomes contract. So this is how it moves. So I believe now all these terms are very much clear to you, starting from proposal, acceptance, promise, with consideration, agreement, and enforceable agreement is contract. So this is how it moves. So this is the introductory kind of thing of contract. Now let's check out the next point, that is, when does agreement become enforceable? Now this is an important question. When does agreement become enforceable? because agreement is agreement. That is promise with consideration, that is agreement. But when it becomes enforceable, there are certain criteria or conditions. If that is fulfilled, then agreement becomes enforceable. Let's check it out. What are those conditions? The first one is proper offer and acceptance. Means we have studied that proposal. So do not get confused with the proposal and offer. Both are basically the same term and more often used interchangeably. But there are certain minor differences that we will discuss later. But for the time being, you just understand it, offer or proposal, it's the same. So proper offer and acceptance, the first condition. But there are certain more conditions that also need to be fulfilled. Parties are competent, that is capacity. We have studied while discussing the immovable property, that is transfer of immovable property. Parties have to be major, means completed the age of 18, and he shouldn't be insane. Okay, so competency means he has to be major and of sound mind. An insane person or a minor cannot contract. So that is the second condition. The third condition is parties have given free consent. What does it mean? That if someone forced you to make a contract, to sign on the paper, then that is not a valid contract. It has to be free will, means you need to sign on the contract paper with your free will. No coercion, no force, and no fraudulent act, no misrepresentation, nothing like that. It has to be free, means free will. Next condition is involves consideration, and that largely involves money. And the last condition is lawful object. So you cannot contract if all the conditions are fulfilled, but the object is like you are contracting regarding the deal of a pistol. So that is not a valid contract because that is illegal. So object has to be lawful. So these are the essential conditions to make agreement enforceable, and when it becomes enforceable, it becomes contract. So again, just check it out fast. Proper offer and acceptance. Parties are competent, that is capacity to contract must be major and of sound mind. Parties have given free consent, no force, no coercion. Involves consideration, there is something like money involved in that contract. Lawful object, it shouldn't be something like unlawful object. So these are the conditions. If it is fulfilled, then the contract, basically agreement, becomes enforceable, and enforceable agreement becomes contract. Now the next point is revocation of proposal and acceptance. This is again conceptual point, please pay attention. A proposal may be revoked at any time before the communication of its acceptance is complete as against the proposer, but not afterwards. Please pay attention what this sentence is saying. A proposal, I repeat, a proposal may be revoked at any time before the communication of its acceptance is complete as against the proposer, but not afterwards. Let it understand with an example. I believe without example it is difficult to appreciate. If someone comes to you, or basically not comes to you, rather called you over the phone or written a letter, emailed you, whatever way used, sent a proposal to you, the person who sent the proposal, he has right to revoke the proposal until that proposal is delivered to you. What it's saying, that against the proposer but not afterwards. Communication of its acceptance is complete as against the proposer. So once the communication is complete, and when the communication is complete, when it is delivered to you. So in whatever way the proposal delivered to you, once it is delivered, or basically the proposal cannot be revoked by the proposer. Until it is not delivered to you, by the time or in the meantime, the proposer can revoke that. But once it is delivered to you, proposer basically cannot revoke it. Now check out the second sentence. An acceptance may be revoked at any time before the communication of the acceptance is complete as against the acceptor, but not afterwards. Again, it is the same sentence. Once someone sent you the proposal and you replied that you accepted or rejected, whatever your reply is, that can be revoked until it is delivered to him. But once it is delivered, you lost your right to revoke that. It's not like that you said, no, I am not interested in buying your property, and when that message is delivered to him, and after 2 or 3 days you are saying that now I am interested. So now it's up to him whether he again accepts, because now you are proposing. Because now you are proposing. So it's now the scenario is changed. Okay, so it's up to him whether he accepts or not. But you can revoke your acceptance or something like if you rejected whatever the things until your message is delivered to that person, or else after that you cannot. The last point of this video is difference between proposal and offer. As I said, we will discuss something in detail on this point, because proposal, offer, there are two terms and you might get confused. And basically the law, that is Indian Contract Act, defines the proposal, not the offer. So what is the difference? Generally, the proposal and offer, both the terms carry same meaning for the contract purpose. However, proposal is a strictly defined term that essentially addressing someone, but the offer is general term and becomes specific only after acceptance of both the parties. First, you focus on the first sentence. That is, the proposal and offer, both the terms carry same meaning. As we have discussed, it has same meaning for the contract purpose. However, proposal is strictly defined, as we have seen that it is defined here in the law, that essentially addressing someone. Means if you are just proposing something, means you are addressing someone. You are asking someone that you want to, basically proposing someone, you want to sell something, or you want to buy his or her car or land or apartment, whatever. So you are addressing someone. So what are the parties involved? They are clearly defined in this part. So that is proposal. But the offer is general term and becomes a specific only after acceptance of both the parties. Here we have highlighted the both. It's not like that. See, in proposal, if I am proposing something to you to buy my car, so basically acceptance from your side required, isn't it? I am proposing, so I am already interested in. But you are interested or not, that depends. So acceptance from one side required, because one side is already understood. But in offer, acceptance from both the sides required. What does it mean? It is confusing, isn't it? Well, it is very simple, believe me. Whenever you go to mall and just check out, there are so many sale and 30% sale, 50%, 70% sale. That is basically offer. Even you ask, is there any offer on such product? Whatever you wanted, something like interested in to buy, isn't it? You ask so many times. If there is board, then fine. So the board that showing there that there is 10% discount, 20% discount, so that is offer basically, isn't it? So it is not like this. The moment shopkeeper put the board there of this much offer or this much discount, it's not like that. You went there and said something like, okay, I accept this. It is a valid contract. Not at all. See, here scene is something different. The board is of course there, but once you go there, you find the board and you like it and you want to buy that, then now you need to propose. Okay, I am ready to buy that. Now the shopkeeper's turn. If he accepts your proposal, then it becomes the valid contract, basically the valid agreement and the enforceable agreement. Otherwise not. So what if you accept that offer, then shopkeeper needs to also accept your proposal. Only then that becomes valid, otherwise not. Keep in mind. Okay, so offer is so general term. It is not like this that addressing someone, rather it is general. So anyone can go in that shop, anyone can buy on that terms and conditions. So that is general. But proposal, it's not a proposal. Just showing the board with some discount is not a proposal. Proposal always addressing someone. But offer here not addressing someone. It is a general term. So that is offer and acceptance. I believe you understood all these terms. So this is all for this video. We will of course discuss all these terms in detail one after another, but for the contract purpose it was the introductory class. So I believe you understood overall what contract is and what are the major conditions of a valid contract, what agreement is, what promise is, what proposal is, so what consideration is. So everything I believe you must understood. So must revise this video for better understanding, and see you in next video.